Welcome to Looking at Legal Stuff. Today we have 10 hearings in a case with a couple where Mama's motioned the court to change the parenting plan due to her concerns relating to Dad and SA. She also has concerns about Dad's sister, who is currently supervising his visitation. The court assigns a guardian ad litem to investigate these serious allegations and orders Dad to undergo a psychosexual evaluation. Dad only has 3 hours of visitation per week and claims he would do anything for his son. He just wants the chance to be more of a parent. But as the months drag on and nothing gets done, Mom gets fed up with Dad's continuing claims that he can't get it done right now because it's too expensive. Let's see how the judge deals with this.
Let's see. And then I have, do I have Ashley, is it Becerra online? And Joseph?
I'm here, Your Honor.
And am I saying the last name correct?
Yeah, you are, Becerra.
Becerra, okay. So this is case 19-300-73008. Let me just get my digital file pulled up here. Looks like you all back on July 14th were in front of Judge Scudder. You guys discussed visitation at that time. I believe Mr. Lawrence was assigned early July, so it's only been about a month. My notes just show that we are here for a review hearing with you, Mr. Lawrence, but the parties, since I'm newer to this case, please let me know if there's something else the parties are expecting to address today.
Your Honor, all I can indicate is that I've made contact with Mr. Becerra. I have talked to him about setting up an appointment next week to visit with him. I will be doing that toward either tomorrow or Friday. And I finally reached Ashley Becerra yesterday. I found out that she is now living in Astoria. And so again, she has to create a new email address for me, and I will be scheduling her for an appointment next week as well. So I'm just getting started on this.
Perfect. So it sounds like in Mr. You know what? I forgot to even look. Do we have Ms. Becerra online? I don't see her. Was she present on July 14 in front of Judge Scudder? She was. And that's when he set this new date. So I just will note in our clerk's notes that she is not present today. My plan is just to set a new review date so that Mr. Lawrence can do those interviews. How much time are we thinking? Probably another 30 days?
Yes, Your Honor.
Mr. Becerra, does that work for you?
I'll make it work.
Okay. Well, thank you for being here today and for being proactive with getting your information to the GAL. If it works for the parties, let's set this to September 6th at 9 a.m.
Okay.
And that'll be for GAL compliance review. And hopefully we will have Ms. Becerra with us at that time.
Okay.
Okay.
All right, thank you, Your Honor.
All right, how about Becerra and Becerra, 19-30037, 73008, on for a GAL compliance review and interim report. So do we have Joseph Becerra and Ashley Becerra?
I'm here, Your Honor.
Thank you, Mr. Becerra. Do I have Ashley Taylor Courtney Becerra present? *6 to unmute on telephone. All right, not hearing a response. I do have Mr. Lawrence here, who's the appointed guardian ad litem. And I guess, Mr. Lawrence, have you been able to meet with the parties and get your process started?
Yes, Your Honor. I met with Joe on the 18th of August, and I met with Ashley the very end of August. There are a lot of allegations by both parties in this matter. I'm going to be, or I have requested documents from both parties, and I'm going to be speaking with collateral witnesses about allegations that have come up. And so it's going to be a pretty involved matter, but both parties have been cooperative.
All right. I see that we have looks like a final review for December 6th. Is that time frame going to work for you, Mr. Lawrence?
I believe it will, Your Honor.
All right. Mr. Becerra, any other things of concern at this point, or?
No.
All right. Well, I appreciate your presence and your cooperation with the GAL. So we'll pass this to December 6th, 2023 for final GAL report.
All right. Thank you.
All right.
Okay.
Becerra v. Becerra, 19-3, 9/30/08. We were here, or scheduled today, to review my guardian ad litem report.
Okay.
Both Mr. and Ms. Becerra are present today. Ashley indicated she can appear by voice, but not by video. And I'm still awaiting more information. And so I have not prepared my report because of that, but I believe I can be ready in 2 weeks on the 20th.
Okay. Let me ask, do I have the parties present on that matter?
I'm here, Your Honor.
Okay, thank
I'm
you.
here, Your Honor. I just can't do video. I'm at work.
Okay, great. So yeah, this, it looks like we are, I noted from our last hearing, this is a fairly extensive process. It looked like, at least at the last time, parties were in compliance with GAL. We just need to set this out a couple weeks so we can finalize recommendations to the court. Do either of you have any objections to that?
No, that's fine with
Well,
me.
it's been going on a long time, and I'm not quite sure why it's taking this long. I mean, I've been forthcoming with all my stuff, and I've even had some of my people that I wanted Keith to talk to reach out, and they never got a response. So I'm kind of wondering why it's being pushed like this.
Okay, well, so he's the guardian ad litem. He decides who he needs to hear from. So that's an answer to one of your questions, but my overreaching question, he was just appointed end of July 2023. So this is not extensively long for a case requiring the type of investigation involved in your matter. So I am going to set this out 2 weeks. So my question is whether you are available December 20th at 9 a.m.
I mean, I'll have to be.
Is that a yes?
Yeah, Your Honor, I will be.
Okay, so Ms. Becerra, I'm sorry, Mr. Becerra, did you say yes or no?
Yes.
Okay. All right, we'll get this set out 2 weeks for review of that GAL report, December 20th at 9 a.m. All right, anything else on this matter?
No, Your Honor.
I did have a
Thank you.
question about the
Hold on, Mr. Becerra, just a second. Mr. Lawrence, I didn't quite catch what you said.
I said I have nothing further, Your Honor.
Okay, thank you. Mr. Becerra, go ahead.
I had a question on the divorce. Is that pending on the parenting plan being done?
I can't give you legal advice. So you're representing yourself. You'll have to look into that. What the case that I have in front of me is a petition for dissolution, which includes the parenting plan and your entire dissolution proceeding.
So it should.
But the way that you all finalize dissolutions when you are self-represented is by preparing proposed orders and having them in front of me.
Okay.
Okay, so it's not something the court does for you. You are choosing or are for some reason representing yourself. So you all still need to be proposing orders. When those final orders come to me, we have a courthouse facilitator you have to meet with first to review those, to make sure they're ready to be reviewed by the court. So all of those steps need to take place. But then, yes, ultimately, those final orders come to me for review.
Okay.
Okay.
All right. Thank you.
All right. Thank you all. We'll see you back in 2 weeks. To the top of our docket, we'll take the Becerra matter, 19-3-007-3008. Do I have Ashley present?
Yes, ma'am, I'm here.
Okay, and then I do see Joseph there. Mr. Lawrence is with us. On this case, I did receive and review Lawrence's report as it relates to getting some sort of temporary order in place. Have the parties both been able to review his recommendations?
Yes, ma'am.
No, I didn't get anything.
Okay. And I'm going to turn it over to Mr. Lawrence here in just a minute, but I'll just let the parties know this case has had, you know, a lengthy history starting back in 2019. And I know you're most recently in front of me because there was an adequate cause motion filed to change a parenting plan. But upon further glance of the history of this case, it does not appear that there was ever a final parenting plan signed by a judge. So essentially, I'm just making a specific finding that I don't need to address the adequate cause motion. Really what we're here on is to set temporary orders and then ultimately final orders. So Mr. Lawrence, go ahead with any input you would like to give the court. It sounds like we might have an issue where Mr. Becerra hasn't yet received your recommendations.
Your Honor, I emailed, and I always ask clients whether it's okay to serve them via email, and he had indicated yes. And I sent the report last week to his email at the email address that I have in the file. And I've sent other stuff to Mr. Becerra through that email and never had a problem. So I don't know why he didn't get a copy of the report. As far as the report itself, it's pretty extensive. I would ask the court to follow the recommendations.
So, Mr. Becerra, are you able to check your email to see if you have it?
Give me 1 second.
Okay. And I'll just tell you, this is a case where I really will need Mr. Becerra's input. There are some recommendations that I think financially could impact you that I wanted to talk through today. Mr. Lawrence's report is very thorough and very detailed with very specific recommendations. And some of those recommendations, I need to chat with you, sir, about, whether these are things you can actually get done.
Oh, sorry.
No, go ahead, sir.
So I just checked my email, and the last email I got from him was on the 4th of December.
And is that's not the report?
No, that was saying that he was asking for a continuance.
Okay. Oh yeah, that was right before our December 6th hearing. I don't want to prolong this. Could we set this over just to next Wednesday? I don't know if the parties are present. I know that's a holiday week.
Ma'am, I would prefer if Mr. Lawrence could maybe try and email that again to Joe to have him review really quick.
It's
because my son's due to go back to him this weekend, and with those recommendations, I don't feel that that's the best in my son's interest.
well, I understand, ma'am, but I have some heartburn about the recommendations. I think some of the things based on what we actually have evidence of, or not things I'm going to be doing, but I really need Mr. Becerra to have reviewed the report in its entirety. There are things that I am likely going to recommend. But I am not, without Mr. Becerra reviewing that report, I'm not making changes to visitation today. I would ask that the report be resent to Mr. Becerra. Mr. Becerra, if you don't receive it by the end of today, please reach out to Mr. Lawrence so you guys can figure out an alternative method. And then I'd like to set you on to next Wednesday at 9 a.m. to go through what I believe the temporary order should look like. And I am likely going to be discussing some options with Mr. Becerra to address some of the concerns Mr. Lawrence raised.
Yeah, when our son was in CPS custody, he never finished his second psychosexual evaluation that was required by CPS.
Yeah, that is.
So that's kind of.
Yep, those are definitely things we're going to talk about. But I have to take into account that most of what is being said are allegations right now. And so I'd have to tread lightly on what I'm actually going to require Mr. Becerra to do. Right now, supervised visitation is in place. I understand there's a question about whether
No, it's not. He's not being supervised. He's being monitored by his twin sister or his girlfriend's mom and her husband.
So, Mr. Becerra, what's going on with visitation right now?
Your Honor, she is incorrect, and it was put in when we purchased the minutes too. It's to be monitored, not supervised by. I have Michael Wolf, Cindy Wolf, and my sister Michelle Medina, and we are to stay the night with them, and I do every time, and I have Michael Wolf here, so if you wanted confirmation that I stay the night here with him.
I think you're playing a game here, sir. There's not, the court's minutes list supervisors, not monitor.
Yeah, they're with me.
Semantics with me. Hold on. So are you telling me that you're not, at all times when the child is with you, there's not one of the 3 approved supervisors with you at all times?
No, I'm not saying that. No, they're with me. I hang out with them all the time. If we go to my sister's, we're with her. If we go over here, we're with them. We go to church, we do Bible studies. We're here. We're with them.
But there's also a 2-hour drive between his sister's house to Cindy and Michael's house.
Sir, you are skirting what supervised visitation is. And I'm looking at Judge Scudder's minutes as well. He specifically uses the word supervisor. He does not use monitor. When the court requires supervised visitation, that means 24/7. That doesn't mean we're giving you an hour alone in the car with the child. It is at all times you have a supervisor with you when you are with that child. And that is because of the court's concerns. So are you telling me that is not happening?
Your Honor, I didn't understand that. I explained to the judge that I have to drive from Longview to wherever I have to. But if it pleases him, I will have one of them all the time. I don't care. Doesn't bother me.
Ashley, are you the one who is doing the meetup location with the child?
Yes, ma'am. I take him up and drop him with his father.
Okay. So then, and are you guys still doing that at the Hall of Justice?
We do it either at the Hall of Justice or at the Three Rivers Mall, just kind of depending on, because I also have to pick up my 12-year-old daughter the same days. So
are just until we're back next Wednesday, when you get, so the visitation will start, it'll occur on Friday. If you get to that location and one of those 3 approved supervisors is not with Mr. Becerra, you do not need to transfer the child.
okay.
Okay. So Mr. Becerra,
And
you're,
then
go
is
ahead.
there actually a signed order for these visits? Because the last time I went and looked, there was no signed order that says I have to give him to him. There was just the court minutes. We don't actually have a signed parenting plan.
I do see that from the July 14, the July 14 appearance where the court ruled on visitation, with Judge Scudder. I'm not either seeing an order to that effect. A second, I'm looking at the follow-up notes. And I think that's the date also that Mr. Lawrence was appointed. So since that time, it's been review hearings. So no, there is not an order. I can do one today for you, just based on the judge's July 14th order. If the parties feel like that is necessary, I'm happy to get it done. But
I was just wondering because I've been giving him to him because I thought I absolutely had to. But with the new information that Mr. Lawrence has provided, I honestly don't feel it's the safest for my son to go with his father.
well, I want to be careful here because I'm not going to be adopting all of Mr. Lawrence's recommendations. I think some of it's based on, I as a judicial officer have to determine what I believe there's evidence for and what is speculative. And so I understand the concerns of Ms. Becerra and Mr. Lawrence, but I don't agree with all of the recommendations. I think some of the concerns aren't based in what we have evidence of. I'm not saying that won't change as we go through this investigative process. But right now, what I'm going to say, because I am going to be making changes once Mr. Becerra has a chance to review the GAL report and tell me what he agrees with and what he objects to, I'm going to be making changes on Wednesday. So I would say just for this weekend, please stick to Judge Scudder's ruling about the transfer on Friday, and then coming back on Sunday. But Mr. Becerra, if at any point Ashley becomes aware that there is not one of the 3 approved supervisors with you and the child at all times, she absolutely can come pick up the child. That isn't the judge in what I'm reviewing from the 714 ruling was very clear about that.
Okay, I understand, Your Honor. I did have a concern though. She is, and I have documents a few times now. Her car has broken down and she has gotten pissed at me and cussed at me over text because I said she needed to figure out how to get him to me because it's not my responsibility, as in Judge Scudder's thing saying that we had to meet in Longview. And
And
pretty
I
much
have that
telling me that
fixed
she
as
wouldn't.
of today. I'm buying a brand new car. So
Hold on, I want him to finish. Hold on, I'll come to you in a second. Go ahead, sir.
And there's been another time where I've had to go, the first actual pickup, me and my sister had to go to Astoria, all the way to Astoria, just so I could see him.
So what's your
And,
question? What are you asking of me?
Well, I don't know exactly what to do in that situation because I don't want to call the cops on her. But what am I allowed to, what can I do is what I'm asking, because I don't think that's fair.
That her car breaks down so she can't get the child to you? I'm not following.
Well, and my son also told me it didn't break down, that it got hit by her boyfriend. So I don't know. I think he is 4, so I don't know if I can take that, but it's just, it kind of seems like a game. And I don't know. I guess I don't know what to do in that situation because I don't want to, cause an issue.
And you work with the mother of your child and figure out how you both can coordinate transfer of the child. I'll tell you both, as you both are navigating single parenthood, and at some point, I bet both of you will have an issue with a vehicle that breaks down. So please just be helpful to each other. I'm not getting the indication that either one of you is trying to keep the child from the other. So just do your best to work with each other. If she says her car breaks down, find a way to meet her somewhere. Well, we're gonna.
Yeah, unfortunately, my car did break down. I put over $1,200 worth of work into getting my car fixed so that I could take my son to his father on his weekends. And unfortunately, everything that I fixed on it has not worked. Fortunately, I am on my way to go pick up a brand new car today that is running bought from a dealership, so I will have no further issues getting my son up there to his father for his visitation.
Okay.
It
So,
was one instant, the first weekend, it was because my tire blew out on the way there.
well, it sounds like Mr. Becerra, she is working to remedy that issue. I'm gonna see the parties back on December 27 at 9 a.m. And then again, Mr. Becerra, if you don't have that report in your email today, please don't wait till next Wednesday to tell me that. Reach out to Mr. Lawrence, okay?
Okay.
All right, thank you all.
Your Honor,
Thank you.
before we go,
Yes,
I'd like to ask Mr. Becerra if the email that I have for him is accurate. It's J.
I'd really like, hold on. I'd rather you didn't say my email to everybody.
Okay, then I will send you a test email to make sure that you get it. And then from there, I'll send you the real report.
Do you have, I believe you, well, yeah, because I've gotten an email from you before. So yeah, if not, I will call your office.
Thank you.
Yep.
okay, then I'm gonna go to number 2 on the docket, 19-300-73008. Ashley Becerra and Joseph Becerra. And I believe I saw Mr. Lawrence. Good morning, Mr. Lawrence.
Morning.
I see both parties present. Are you folks able to unmute and turn your cameras on?
Yes, Your Honor. I'm here.
Unfortunately, I'm at work. I can't turn my camera on right now.
Okay, no problem.
I wasn't able to get 2 Wednesdays in a row off. I'm sorry.
Yeah. Okay, so I have this on for what I believe to be the final GAL review. I think we set it over. I think we set it over last time because Mr. Becerra wanted time to review the report. Mr. Becerra, have you received that now and had a chance to look at it?
Yeah.
Okay. Are you in agreement with it or are you objecting to the recommendations?
Objecting.
Okay. And Ms. Becerra? Oh, Ms. Becerra, did we lose you? Are you still?
No, I'm still here.
Okay.
Recommendations.
Sorry, you cut out. I didn't hear what you said.
I said I'm agreeing with the GAL's recommendations.
Okay. So, Mr. Becerra, what are your points of disagreement?
Well, they're bringing up my charges, which were dropped, and I don't think that's relevant. It's not evidence. It's not facts. If they want me to do another parenting class, I can do it. I did a parenting class, a DV class, mental health evaluation. I still go to counseling at Core Health. I have 2 counselors. So I don't know, but I think I don't agree with it. It's really irritating to keep having to defend myself. And all I want to do is be a good dad to my boy. You know, I'm not saying that, you know, anybody's invalid for concerns, because I get it. They're kids and it's, you know, you have to be careful, but I've done nothing to my child. I would die for that kid. And I think that Ashley is, I don't want to accuse of playing a game, but I have evidence that she got back with me a year after the allegations. I have text messages, proof, everything. I think she's mad that I was not wanting to be with her at this point and is retaliating, because she even put in text messages
she wanted to work this out outside of Keith. And so I don't know. I'm just a little, I try to remain calm with all this, but this is, I've even taken her out to dinner. I have a text message about thanks for dinner. I was trying to be very, very friendly and calm with everything that's happened to me in this. So I'm trying not to blast her because I could have done all that and I could have thrown out all this stuff that I have, but I don't think that's the right way. I want to be a good parent and co-parent with my ex so that my child sees that his parents can get along. So why I was opting 50-50, or if I just get the every other weekend, I'll take it. That kid's more important than anything to me. I've taken and messed with my schedule so much for him. I've told them I can't work in this time because I have him, and I have a good paying job that I don't want to lose, but if I had to lose it for him, I would. So.
Well, so we're in an interesting scenario in this case in that I see that back in June, and I obviously understand there's been a lot at play with both parties and child. But back when you all were in front of other judicial officers, you were on for, Ms. Becerra had requested a change in the parenting plan and an adequate cause finding. And what this court did was appoint Mr. Lawrence, I guess, to investigate this case further so that the court could make a better determination on that. I think the judicial officer, as we talked about last time, put into place some changes in visitation. What I don't see, and Mr. Lawrence can tell me if I'm wrong, what I don't see is an actual order or decision on the motion for adequate cause.
I believe that's correct, Your Honor. In my investigation, I found 3 different parenting plans that the parties were referring to, and had very difficult time finding anything that the court had actually issued.
And I'm just going back now into 2021.
The last judge, he said he was gonna sign an order for the new parenting plan that we were supposed to go by, but he never actually did it. So what we've been going off of was the court minutes that we got printed out.
Well, and usually when you're pro se, meaning you're unrepresented, the party who is proposing the temporary order needs to prepare that and supply it to the court. Now I'm all the way back in 2020. Okay,
I
so
did supply one in June, but he decided differently than what I had proposed. So
right. So here's what I'm looking at. Back on April 17 of 2020, you all did have a temporary family law order that was in place and signed by a judicial officer back in 2020. And then I see it, like Mr. Lawrence suggested, I see a lot of potential proposals, but nothing final signed. And then in 2022, the clerk issued a notice for dismissal for want of prosecution, which just means there hadn't been any activity on the case in over a year. And then at that point, still nothing happens. But in June of 2023, Ms. Becerra files this petition to change a parenting plan. But the problem is I don't think we don't have any final parenting plan. We just have a temporary parenting plan from 2020.
yeah, and I didn't know that it was still just a temporary one. I thought when they signed it back in 2020 that it was a final parenting plan.
Yeah,
I
it
didn't
says,
realize it was only a temporary one.
yeah, it says court order signed by a judge or commissioner. This is a temporary order. And in that order specifically,
In that order, I think he was only getting 8 and 3 hours on Saturdays, but he was completely unsupervised with that visitation.
yeah, this one, I'm just going back. There was some language the commissioner wrote in there. I was just looking at 4/17 of 2020. Yeah, this one that Commissioner Busby signed, the child was to remain in the temporary primary custody of the mother pending GAL investigation and review. The father shall not be prohibited from having contact with the child, have residential time and visits with Aiden once a week for a period of at least 3 hours. With the anticipation of increase in the near future, parties shall use a third party to coordinate visitation, and this will not be a violation of the protection order. And then I know you all had some unique situations kind of happen in between then. So what I want to do today is a couple things. I want to specifically note on the record that in my ruling, I'm going to strike the motion for adequate cause because we don't have to have that, because we don't have a final parenting plan. We only have temporary orders in place. So I don't need to make a finding of adequate cause to move forward. I think the final parenting plan is still very much on the table. I want to talk about a couple of the recommendations. I am adopting, and the parties need to make note of this because you will need to prepare a new temporary order for the court to review and sign. On page 15 of the GAL's report, as part of a temporary parenting plan, I am going to adopt findings 1, 2, and 3. I want to talk about number 4 and 5. I am going to adopt number 6 as it pertains to neither party is to speak derogatorily about the other in Aiden's presence. The court should be advised that these are temporary recommendations. The last paragraph, the last sentence regarding polygraph and psychosexual evaluation are what I want to talk about now. So Mr. Becerra, this is recommendations 4, 5, and the last part of 7 regarding a polygraph or psychosexual evaluation. Those are the ones I want to talk with you about. And the primary reason I wanted you to have read the report in its entirety before we made this decision. I've thought a lot about this case after reviewing the GAL report, and I have hesitation to order polygraph. As most people know, we don't accept polygraphs as evidence in court cases.
Opportunity to explain why.
But I do think that Mr. Lawrence's concerns are not misplaced. And I do think before the court makes a final parenting plan, we would like to know more. We would like to make sure that the child is safe. And so Mr. Becerra, I wanted to kind of pick your brain. You are free on your own to do polygraphs if you would like. I see that you've done one in the past for a different case. That is your choice. I don't feel comfortable making that court mandated by any means. But then the option I'm left with is a psychosexual evaluation, which we do use frequently. And that's where you meet with a provider, an expert really, and they would make a recommendation to the court, which I'm more inclined to do. But they can be expensive. And I guess, Mr. Becerra, I wanted to know from you whether that's something that you think you have the means to do. I don't want to set you up for failure, or if you have other recommendations on how to satisfy some of the GAL concerns and, court questions.
I'm not comfortable with, I've already done a psychosexual with no polygraph. And that was submitted a while back. I don't have the means to do really anything. I can take classes if people want. I don't care. I'm tired of being put through the ringer and the stress. I'm going through counseling all the time. I've been there for a couple of years now, and they're not happy with everything that I've had to go through, and they've had to work with me, and I've not been okay a lot. And but I mean, I don't know. I don't know. I just started working, making enough money. I have a second job to pay for a car because I didn't want to, when child support starts being taken out, I didn't want to not be able to afford my car because I need that to go to work. So I do extra work. I mean, you could even look at all my visits from when we were in DCYF stuff. I was put into monitored, and they had none. Even Judge Scudder, he said in his last thing that I had perfect ones. They never had a complaint. They never thought that anything was, and I was left alone with my son. And given it was only 15 minutes at a time, but I actually was so comfortable. I said, you don't have to go downstairs. You don't have to leave us alone. I had nothing to hide. I wasn't worried. So, he could shoot. Lawrence could go and be on my visit. I don't care if he wants to see, or I don't know how to, I've had people on my visits. I don't care. It doesn't bother me. I did this for 3 years. And I bonded with my son, which every single person said that was amazing, because it's hard to bond with a child just through visits. And I was doing 6 days a week with him. I tried not to miss. I was in 2 car accidents. And I still went to him. I just told him, hey buddy, you got to be careful with daddy. Daddy's hurt. But I just wasn't. I even went with a concussion. The kid's everything. And I really don't know how to, satisfy anybody with anything, because there were allegations. It got dropped, but I get it.
Well, and what the court has to, I mean, there was probable cause found. So I just want to be clear on that. So it did move forward through that point, and it was dismissed without prejudice, which means it could be refiled within a statute of limitations period. So, so I guess that's, I'm just being realistic that, and I'll be honest, I have concerns about the parenting that has happened with both of you. I mean, there's, as Mr. Lawrence has pointed out, Ms. Becerra has also, I think, put the child in some situations that the court isn't totally comfortable with either. So, I want to be very clear about that. And here, so Mr. Becerra, you're telling me that there are counseling records related to some of the concerns that we're discussing here today. If I were to make those part of your requirements, are you still undergoing counseling?
Yeah.
How often do you go?
So I see a peer counselor and a regular counselor, but they've all switched. So I have people right now, but I continue to go to it because of the stress I've been under, and to work through a lot of issues.
Is it is it mental health, or is it related to the sexual allegations, or?
No, it's mental health. And it was also something I chose to do because the court was asking me to get a mental health evaluation, and I cleared. I was good. But I thought it would be good under my own to go for it, to have that outlet.
Mhm.
The ones I have now are new to me, but they're good. They're giving me, because I lost my mom through this stuff
Mhm.
about 2 years ago, and if it weren't for them, I probably wouldn't be okay. They've helped me through a lot of my stuff. But I don't know if it pleased anybody, I could do mental health for sexual health stuff. I don't care. It really doesn't bother me.
Yeah. And let me
Really,
understood.
but
Yeah.
Your Honor, can I bring up one concern with the psychosexual evaluation,
Yep. Go ahead, ma'am.
at least from my perspective?
Mhm.
He did one through CPS that was prior to the charges being brought against him for my daughter. And then the judge required him to do a second psychosexual evaluation after the charges and the court thing had all happened, so that they could get an accurate account, because the first psychosexual evaluation had no idea about the pending charges. He did part of it, and then they asked him to come back in to do the polygraph part of it, and he absolutely refused and never completed that second psychosexual evaluation through our CPS dependency. And he's never had a polygraph, as far as I know, about any of the allegations against any of the other 4 children, other than the one that he did regarding Aiden.
Yeah, and that's where I've talked about this with other folks on the bench, and I just, our take is ordering a polygraph when it's not something we would deem admissible evidence. It's just not something I'm comfortable with. But I'm balancing that with, I have to make a decision what I think is in the best interest of the children. And I agree with Mr. Lawrence. I don't think, Mr. Becerra, that I have enough information to say that I don't have concerns. And so that's why I'm kind of leaning on you to see what you are willing to do. I mean, I am inclined to order a psychosexual evaluation, not the polygraphs. But I am inclined to order that, and I'm just wanting to get your feedback on whether you think that's something you can realistically get done. And go ahead.
it's as you know, they're lengthy processes.
Yeah, they are.
And where she's wrong, the first one was about the allegations, so they did understand that. And the second one, the lady, I won't talk on it because it is
Okay.
part of that. And I was advised not to.
Okay.
And out of all respect, I don't mean any disrespect. I just
Understood. It wasn't ordered by this court, so I'm not going to hold you to whatever happened there. But it does sound like, here's what I am inclined to do is to, because I do agree. I think there's enough here for concern before we enter permanent parenting plans. But I also, Mr. Becerra, am trying to balance that with, I'm not here to hold every allegation that someone could make about you against you. And I think the way for the court to know whether to move forward is to get that psychosexual evaluation. But I'm not ordering the polygraph. I don't think that that's something that would be valid standalone. Obviously, if the psychosexual evaluator wants that for their own data points, that's up to them. But for the court's perspective, I'm not going to order standalone polygraphs. So what I'm going to do, besides adopting on a new temporary order, is 1, 2, and 3. I am going to strike 4 and 5, my new recommendation or my new order will be that Mr. Becerra complete a psychosexual evaluation with the input of Ms. Becerra and the GAL. And then under number 7, that last sentence then from the court's perspective would read, once the psychosexual evaluation is completed, the court will review further recommendations.
In
Okay,
your
so which
honor,
one?
do you go through and order the child support? Because at this point, Washington State has dropped child support, and Joe has only paid me child support outside of an order once since I've had my son back in my custody.
Right.
Is that something we go through you, or do I do it through Oregon since I live in Oregon now?
And where do you reside?
I live in Astoria,
Okay.
Clatsop
Yes.
County. I
Yes.
moved down here to get out of the relationship that caused the CPS case.
Okay. Ms. Looney, do you know the answer to that? I don't want to put you on the spot here, but since let's see if she's with us. I don't want to.
I apologize, Your Honor. I
Oh.
am here, but I wasn't
No.
focused on this hearing since I'm not involved.
Understood. And I don't, if you aren't comfortable answering this, don't. This is a situation where we have a current parenting plan that's been in long works while these parties resided in Washington. Ms. Becerra is now in Astoria, and we're going to be entering a new temporary order. And she's wondering about whether she needs to go through Oregon for child support or file her documents with you.
I'm just checking to see if they're in our system, Your Honor.
Okay.
We might not be because they closed it out about 2 years or a year ago, 2 years
Well,
ago, I think.
I see that when this case was, when the clerk entered the notice for dismissal for want of prosecution, then the Ms. Looney's office did file a notice of withdrawal. But it does say all further notices should be served directly on state of Washington at DSHS.
That's correct, Your Honor. And I'm just looking to see if they have an active DCS case open, and I don't see one currently. So at this point, I would not have an answer for that.
Perfect. Okay. Thank you. I appreciate that.
No problem.
So,
Yeah,
Miss,
I'm not receiving any state assistance other than like food stamps and medical for our sons. So
okay.
unless I get TANF, they don't require child support orders be in place.
Yeah. So Ms. Becerra, I can't give you legal advice from the bench. So here's what I'm going to say. I do want you to fill out a new temporary parenting plan based on my ruling today, which is based on the GAL findings. And then we'll set a presentation date for that, for a judge to sign that order. And then you can serve that. If you want to get some legal advice on whether to serve that in Oregon or Washington, feel free to do that. But you can request child support based on that new temporary parenting plan being signed.
Okay.
And
Joe and I had tried to work out child support outside of having to do it through like the state and making the state take money out of his check and send it to me and all of that. But like I said, he only did it 1 month and then hasn't, and told me through text message that he wasn't going to give me any more child support until this all dealt with.
Yeah. So that's child support isn't in front of me today. So again, I'm just going to say, what I can do is Ms. Becerra, how long do you think you'll need to get the new temporary order proposal filled out per my ruling today and then back in front of this court?
Well, considering I live an hour away and I work Monday through Friday, 8 to 5, I'm gonna have to take a day off so that I can come up there and file everything.
We have this docket every Wednesday at 9 a.m. So do you want me to set it out 2 weeks to January 10th?
I will try to have it in before next Wednesday. I can see if I can come up and do it Friday.
Okay, well, it wouldn't be in our system yet. So why don't, if you're planning to do it Friday, let's still stick with January 10th. So it has plenty of time for Mr. Becerra to receive a copy. Please send a copy to Mr. Lawrence. Mr. Lawrence, are you staying on this case for a bit? I'll probably need, if you are willing to do so, I'll need to authorize probably additional resources.
That's correct, Your Honor. I usually am until there's a final parenting plan. Before the court ends the hearing, though, I would like to make a couple of comments.
Yes, I'll come back to you in just a minute. So Ms. Becerra, we'll set this for January 10th at 9 a.m. And again, please serve Mr. Becerra and Mr. Lawrence with a copy of what you're filing with the court, okay?
Okay, can I email it to Mr. Becerra or do I need to hand it to him?
Mr. Becerra, would you accept email service?
Yeah.
Okay, yes, you can email. Okay, Mr. Lawrence, go ahead.
Well, Your Honor, I understand where the court is right now and the ruling you've made. I just wanted to share a couple of things. I was working with sex offenders for the Cowlitz County Juvenile Department in 1990 when the Community Protection Act went into effect. And it required special certification for anyone evaluating a sex offender and treating sex offenders. And mental health centers were specifically forbidden from working with sex offenders in that statute because of the lack of understanding about the nature of the sex offender dynamic. The reason that the polygraph is part of the evaluation process is that if an alleged offender goes in for an evaluation without the polygraph, most of the time, and if not all of the time, they are going to minimize and deny any activity. And the evaluation becomes almost worthless at that point because there's nothing to work with if the person is denying that they have done anything. That's why the polygraph is so important to understand exactly what we're dealing with. Now, I understand that the court has spoken to the other judges, and I understand that this is your ruling, but I want the court to be prepared that the evaluation, if completed, is probably going to have minimal value.
Thank you, Mr. Lawrence. I do appreciate that input. I did review in depth your credentials regarding this specific topic that were in the report. I appreciate that. Yes, I disagree. I don't think that a psychosexual evaluation, as I have ordered it, is going to be of minimal value. What I have stated specifically on the record is that if the evaluator believes a polygraph for purposes of their data points is appropriate, they can certainly discuss that with Mr. Becerra. What I don't believe that this court should be doing, which is supported by other judicial officers, is ordering standalone polygraph examinations. We don't, if that was presented as evidence to us, we would deem it unreliable. So that's what I guess my ruling is very specifically that I'm not ordering the polygraph first and then determining whether to do the psychosexual evaluation. In essence, I am leaving it up to experts in this field to decide what they need for their data points.
All right.
But Mr. Lawrence, I do appreciate your wealth of experience and knowledge in this field. And I do understand why you are making the recommendations that you are.
Thank you.
Okay, so I'll see the parties back January 10th, 2024. Oh, Mr. Becerra, did you have a question?
Yeah. So am I getting 3 hours professionally supervised? Because that's confusing.
This is, so I guess that is a clarification we need to make. in Mr. Lawrence's report, and thank you for bringing that up. Right now, I believe it's your sister who's doing the supervision. Is that correct? Is that yes?
Yeah.
Sorry.
Yeah, sorry.
Okay. And I think Mr. Lawrence's question was, we should talk about whether the sister is the best supervisor for this situation. I understand what the potential concerns might be. Ms. Becerra, are you comfortable with Ms. Medina, or are you requesting a change?
Joe already knows I'm.
Sorry, you're cutting out. I couldn't hear what you said.
Oh, hold on. I think my headset's
Okay.
going dead.
Okay.
So I am going to request a change on the supervision person. Joe will obviously deny this fact, but he has told me in person that during our CPS investigation, Miss Medina would allow him around our son outside of the approved hours and times that he was supposed to see him. I don't feel that she is necessarily the most like by the book, rule abiding person to be supervising the visitation with my son. Just because of the prior things that have happened. There was reports made to our CPS person at the time when I found out that he might be having extra time with our son, and then shortly after that, our son was removed from Michelle's care, put into Brielle Balzer's care, and then he was having supervised visitation through an actual supervision company after that, because of concerns of her not abiding by the rules. I don't like the other two people that he has supervised are the best option either. Cindy, whatever her last name is now, it used to be Balzer. I think it's Wolf now, and Michael Wolf. They are the mother and mother's husband of the kids' previous foster parent. And that foster parent tried to keep me from getting my children back by lying about me in reports. And so I don't feel like they are necessarily not like, I don't think they're not going to pick sides and just, allow him to do whatever he wants to do. Just because they never wanted my son to come home to me to begin with. So, Mr. Lawrence, what are your concerns with Ms. Medina, if any?
My only concern, Your Honor, was whether or not the relationship between her and Joseph would be a potential situation where she may hide some information. That's why I brought it up, just for discussion. I wasn't suggesting that she necessarily be removed.
Understood.
What I understand from Ashley's comments are that she hadn't been objecting to Ms. Medina supervising Aiden currently, but had an issue that occurred back when the kids were in foster care and removed from the home. That doesn't seem to be relevant today to me. And unless there's a party that both of these folks can agree on, particularly unless, and again, I'm qualifying my statement here, that should the psychosexual evaluation prove that there is some issue, then I would want to immediately revisit this issue. But for now, I can live with Ms. Medina.
Yeah. And that's kind of the way I'm leaning as well. And, Ms. Becerra, I want to be perfectly blunt here. This is a situation where I have concerns about your parenting choices as well. So I need to be very, very clear with that. I think there's a lot of casting of doubt on Mr. Becerra's parenting, and I'm not saying it's without some factual basis, but I don't have anything hard pressed in front of me to say that Ms. Medina right now is an inappropriate supervisor for where we are at. I agree wholeheartedly with Mr. Lawrence, though, that should, as we continue down this path, additional information come out that Ms. Medina is not an appropriate supervisor, this court absolutely will revisit that when faced with that type of specific factual allegation. I am going to leave Ms. Medina right now as the appropriate supervisor for the reasons I've stated, but also I am placing on Mr. Becerra a large financial expenditure and adding professionally supervised visitation. I think financially is just out of the question, given what I have in front of me. Again, like Mr. Lawrence, I'm going to preface all of this with, should the evaluation tell me something differently, I certainly will revisit this and we can talk about whether professionally supervised visitation is warranted. But right now, I don't believe that I have enough in front of me to say that it is. So I will, rather than professionally supervised visitation on this temporary basis, it will be with the previously agreed upon family member, Ms. Medina.
Okay, so does that mean I drive Aiden up and drop him with Michelle for those 3 hours for Joe to see him and then pick him back up? Do we have to meet somewhere? Is that just going to be on Joe and I to decide how and where those 3 hours occur?
Didn't we already discuss that when you were in front of Judge Scudder?
No. I mean, I take him up and I drop him at the courthouse with them, but I didn't know if, is there going to be a specific place that you want that visitation to happen? Am I, is it supposed to be public? Are they okay to go to his sister's house for those 3 hours? I just want clarification so that when, things are said, then I don't, go against what your recommendation is for that.
Okay, what are you wanting clarification on?
So he is just getting the 3 hours of supervision, right? Supervised visits a week?
Correct.
Okay. So
On
then
this temporary basis, before he
Okay.
undergoes additional evaluations, yes.
Okay. So is it just between me and Joe to decide what day and times work for him as far as those 3 hours? Or are you going to set aside a certain day?
So I'm going back to the notes. Previously, I believe, if these notes are correct from when you were in front of Judge Scudder, that each party would pick up at the beginning of their own time. And that I think the court set Saturday at 10 a.m.
That was one of them that he said, and then he went back to Friday nights at 7 p.m. to Sunday nights at 7 p.m.
Okay. And transfer to occur at Hall of Justice.
Yeah.
And then you were encouraged to work together if those times don't work.
Yes.
Okay. So during the 3 hours, I'm not putting any limitations on where that visitation is occurring, except that it has to be with Ms. Medina present. I believe that the transfer of the child are you still doing it at the Hall of Justice?
Yeah.
We either do it there or at the mall, because I also pick up my other daughter at the same time, generally, if we're doing Friday night exchanges. And so it just kind of has depended on where I can meet both parties at the same time.
Okay, so it sounds like that's something you guys are already working together. So why don't we say Hall of Justice or Three Rivers Mall? Parties to work on that together. Those will be the two places. It sounds like Ms. Becerra, you will be the one bringing him here for the 3 hour period. So what works for you?
I work Monday through Friday, 8 to 5. So if it can be a Saturday or Sunday, that's okay with me.
Mr. Becerra, what works for you and Ms. Medina?
I don't know on time,
Okay.
but Saturday can work, and I can figure out the time with Ashley.
So let's say a 3-hour period on Saturdays, time to be coordinated between the parties.
Mhm.
And if you guys could coordinate that, let's say by Wednesday of, 3 days before, so Wednesday of the week, have coordinated your times for Saturday.
Okay.
And then again, no other limitations I'm placing on visitation except that it'll remain supervised. January 10th is when I have you all coming back for presentation of that order. And then let's set a review. I know Mr. Becerra getting in for an evaluation is going to take some time, but I would like to get a review on this docket so that once you have started that process, the court can continue to modify visitation as appropriate. If we
Okay,
set a review for February 7th, that's about a month out from presentation of the order. Will that work for the parties?
Yeah.
Okay, we'll do the first review February 7th at 9 a.m. primarily to see where we're at with the evaluation.
Okay.
Okay, any other questions for me?
On the parenting class thing,
Mhm.
do I have to come up to Washington to do that parenting class, or can I take one here in Astoria?
That I have
Is it just as long as it's 11
wherever
logic parenting class?
they offer it.
Your Honor, if I can interject,
Please do.
some of these are online. Love and Logic, and I believe
Okay.
Children in Between may both be offered online.
Okay.
Yeah, I'm not placing any limitations on where it has to take place, just that it needs to take place. So online, in person, whatever state works, just get it done. That's all I care about.
Yeah, I know. I was just clarifying because with the CPS case, I had to drive all the way to Longview like 3 times a week for the classes. So,
Yeah, I wonder and were those done through CPS itself or just recommended by them?
yeah, it was done. They were recommended and they were done through Stacy. I cannot remember her last name. She's there in Longview. She does both the DV classes and the parenting classes.
Yeah, no, this is much more, I believe Mr. Lawrence is very accurate that a lot of this you can do online.
Okay.
Especially post Zoom world. So, okay, well, we'll see the parties back on the 10th. Ms. Becerra, if you fill out that order, if there's clarifying questions that need to be made on the 10th, we can deal with that at that time. But go ahead and fill it out to the best of your ability to present for the court.
Okay, and that's just the temporary order, right?
Correct.
Okay.
Okay. All right. Thank you all. I appreciate your time.
Next, I have the Ashley Becerra matter and Joseph Becerra matter, cause number 193730-08. I'll ask those if those parties are present. Ms. Ashley Becerra, are you here?
Yes, sir.
Okay, welcome to you. And Joseph Becerra, are you here today?
Yes, Your Honor.
Okay, great. Welcome to both of you. We're here today for a presentation from an order or a hearing that was held on December 27th. And so on the 27th, both parties were present and there were findings made by the court. And I'm just curious, did the parties submit proposed orders for the court to review and sign off on?
Yes, sir. I did it that Friday. I drove up, took the day off of work and submitted all the parenting plan per her proposed orders.
Okay. And we'll check with Madam Clerk. Oh, yeah. Yeah, let's do that. So
Joe and Keith were both served with copies of the paper, and I got confirmation that they both received them.
okay, great. So Madam Clerk, she just stepped off out of the courtroom for a little bit. She's going to go check in the back area of the courthouse. It's unusual that we don't have all the the proposed orders here. As a general rule, I come in with a stack of paperwork, and I wasn't given a stack of paperwork this morning. And with your case and another case, I think it strikes us all a bit as being a bit unusual that we don't have those. So she's going to just take a moment to find those documents, see if she can find those. So we're just going to just pause here in the pool, if you will, and just float for a little bit until she comes back, because we really can't do anything without her being here because she's the record keeper. So we'll just pause for a second, and I appreciate your patience.
Okay, I just have a meeting that I'm supposed to be to in like 15 minutes. I'm at work. I couldn't take another day off of work for this. So,
I assure you, we will not purposely unduly delay.
thank you.
Beloved purple file has arrived. Okay, great. Thank you. All right, so we're still on the Becerra matter. So let me just leaf through the proposed orders here. Okay, so I do have a copy of a proposed parenting plan that was presented by Ms. Becerra. And then, Mr. Becerra, did you receive a copy of that proposed order?
Yes, I did.
Okay. And I'll note that Mr. Lawrence is here as the guardian ad litem. He's on the line. Can you hear me, Mr. Lawrence?
Yes, I can.
Okay, great. Welcome to you.
Thank you.
So with regard to the parenting plan, Mr. Becerra, do you have any objections to that order? Meaning, from the hearing that was recently held, did Ms. Becerra accurately capture what the court had ordered at that hearing?
I did have questions though.
Okay. Do you have any specific questions on that proposed order?
So there's two of them. Am I to pay for the evaluation? Because I wasn't clear on that one.
So I did a quick review of the hearing minutes from the last hearing. I see that the court adopted the guardian ad litem recommendations 1, 2, 3, and 6. The psychosexual evaluation needed to be completed, and that's the one you're talking about, right?
Yes.
Does either party, Mr. Becerra, Ms. Becerra, Mr. Lawrence, do you recall if the court specified who would be responsible for that?
I think the court has said he was going to be responsible for that. Because they also said that they weren't going to require him to provide professional supervision because they were already asking him to put out so much money for the psychosexual evaluation.
That's my recollection as well, Your Honor.
Okay, thank you. Mr. Becerra?
Yeah, I don't know. I looked into it and I can't afford one of those. It's at least $1,000.
Okay. All right. As far as it sounds like the court specified that Mr. Becerra would be responsible for paying that, and Mr. Becerra has indicated that that's going to be problematic. So I'm just going to add that to this here. Just one moment.
Your Honor, if I can interject for just 1 minute.
Go ahead.
On section 4, page 3 of the parenting plan, down at the bottom, it says evaluation or treatment required, and it does indicate that he undergo a psychosexual evaluation. There was extensive discussion during the last hearing about whether or not a polygraph examination would also be required. And Commissioner Carmi was not going to specifically order that. However, she did say that in the event that the evaluator felt that he or she needed that polygraph examination, then he would be required to undergo it. And that's not reflected in this particular parenting plan.
Right. Thank you. Mr. Becerra, do you have any input related to that comment?
Yeah. But I think that Mr. Lawrence is just pressing an issue that needs to stop because he's going on the side of being biased and keeps bringing that up. And the judge, she made it quite clear that you know, if it was. So he did say that, but she wasn't going to order a standalone one, and because it can't be used as evidence. So I don't know why he keeps doing that. It's kind of ridiculous. I think it feels like he has something because he keeps bringing up his work history. So it's just
So
seeming
I
like
think he was just bringing it up because I didn't add that on there on the proposed parenting plan, because I just put that if further treatment was needed, that you would follow those orders, and that would be one of those further treatments.
Okay. Well, I appreciate the input from the parties. So on page 3 of the proposed parenting plan, where it talks about the evaluation is required, and that I wrote on the line where it says that Mr. Becerra get the psychosexual evaluation and start to comply with treatment as recommended by the evaluation, including a polygraph if required by the evaluator. So I just added that language. So I think that'll suffice. And that sounds like that's an accurate rendition of what the court ordered on the 27th.
Thank you, Your Honor.
Other concerns, Mr. Becerra, on this proposed order?
yeah. So can we put something in for makeup time, because Aiden was apparently sick, and I'm only getting 3 hours a week, and so when she asked to miss that one last Saturday.
Okay, so let
Yeah,
me just check with the
unfortunately, all three of
parties.
my kids
So
at home got
hold on, Ms.
plague at the same
Becerra.
time.
Ms. Becerra, hold on. So, Mr. Becerra, on the 27th of December, did the court make a ruling on makeup time? Because that's what we're here on today, is basically limited to what the court ordered on the 27th of
Yeah,
December.
no, they didn't, because I forgot to ask anything.
Okay,
I didn't think it would happen, but I mean, if Ashley's willing to, work that out with me, I'm fine with that. But
okay. So I'm gonna pass on making a ruling on any makeup time, just because we're here for presentation, and it's solely what the court ordered back on the 27th of December. So if the parties want to agree, the parties are free to agree with whatever they'd like to agree to. However, if there's a desire on your end, Mr. Becerra, for makeup time, then you could file a motion with the court and have the court make a ruling. But for today, I'll pass on making any
Okay.
decision on that. Right. Any other issues related to the proposed parenting plan, either Mr. Lawrence or Mr. Becerra or Ms. Becerra?
no.
None for me, Your Honor.
All right, hearing no additional items, I have that order and I'll sign off on it, today being the 10th of January.
Your Honor, I do have a question. Are we going to put a time limit on when he needs to have that psychosexual evaluation done, or is there going to be another court date where we can, like, if he can't afford it, then he can't afford it, and that's, a big part of that.
So I'm not sure about the timeline. Was that a discussion that was had before the court on the 27th of December?
No, she just said that he needed to do it.
Okay. All right. So I'm not going to add or detract from what the court ordered on that particular date, on the December 27th. So I'm not going to make any additions as far as time frames. If the parties feel that's important, you could bring a motion and have the court make a specific ruling on that. Otherwise, I've signed off on the order as presented and modified slightly by those two items that I added. One, that if the polygraph was requested by the evaluator, that Mr. Becerra will need to do that. And then I also wrote that Mr. Becerra is responsible to pay for the psychosexual evaluation. All right, so I've signed off on that order. Thank you, everybody, for your assistance today.
Thank you.
Thank you.
Mr. Lawrence has another matter, which is the Ashley Becerra and Joseph Becerra matter. It's 19-3-73008. I'll ask if those parties are present. Ashley Becerra, are you on the line? Not hearing a response from Ashley Becerra. I'll ask if Joseph Becerra is on the line.
Yes, Your Honor.
Okay, welcome, Mr. Becerra. And Mr. Lawrence is here. Again, Ashley Becerra, if you're here, please make sure you're unmuted and state your name. At this point, I haven't heard your voice.
Can you hear me?
Yeah, Joseph Becerra, I can hear you perfectly and I
Oh,
can
okay.
see you. Yeah, thank you.
Okay.
Yeah,
Okay.
that's great. Yeah, thank you. And then Ashley Becerra, if you're here, state your name. Okay, I'm not hearing her and not seeing her on the Zoom. Don't see a name that's representative or close to that name. And the courtroom, there's no persons other than myself and the court clerk. So procedurally, there was a parenting plan, temporary parenting plan signed on January 10th of this year, and it required Mr. Becerra to get a psychosexual evaluation and treatment. And we're here to see what progress has been made. Mr. Lawrence, are you aware of any progress?
Your Honor, I checked Odyssey this morning to see if Mr. Becerra had filed that evaluation. I found nothing. I've heard nothing from Mr. Becerra, and so I assume that he's still in process.
Okay, thank you. Mr. Becerra, any updates you could share?
I'm not going to be able to afford that. It's over $1,000. I don't have that kind of money. I'm paying Ashley child support, not by ordered, but her and I agreeing, um, and all my bills and rent and stuff to keep myself housed. And obviously, I'm working. I'm at work right now, so I just
Okay.
I don't see it feasible to be able to pay for that.
Okay. All right. Thank you for that input. So on page, the temporary parenting plan filed on January 10th, 2024, it says that Mr. Becerra must be evaluated for psychosexual evaluation and start and comply with treatment, including an evaluation and a polygraph as required by the evaluator. And he's responsible for payment of the same. And we've heard from Mr. Becerra that that's very much a strain on his finances. And right now the parenting time is supervised by Ms. Medina.
My sister. Yep.
Yeah, okay. And that's Saturdays for 3 hours starting at 8 a.m. and ending at 11 a.m.
Yep.
Okay. So this is my take on that, is that one, that there's supervised visitation for the child. The child is protected by that supervisor. Second point is that I recognize evaluations are very expensive and money's not growing on trees and it's difficult. So if there's to be ever to be any expansion from that current parenting plan, that psychosexual evaluation would have to be completed. Otherwise, without that, there's not going to be any movement, and that's where it will stay. So
I understand it. I figured that's probably what it's going to be.
yeah,
Eventually, I will try and I will come back to court about it.
okay.
But I mean, if you guys want to put that as the final, that's fine for now. I understand. I do, but until I make good money, then it's kind of hard. And I'll take what I get with him, honestly. He enjoys it all the time. She's worked with me. There was a day that I think I asked you about getting makeup time, and she did it out of her own, and gave me an extra 3 hours.
Okay.
So I did appreciate that for her. So I'm making sure I pay her every month also, because he is my responsibility financially. So
Right.
I do understand.
Yeah, so I think at this point, once you get the evaluation and the treatment, then you could note it up for a motion to expand visitation or change the residential time. But until that time, the temporary parenting plan of January 10th remains. Mr. Lawrence, any comments on that?
No, Your Honor, that would have been my recommendation.
Okay, all right. And so at this point, I'm not going to be setting any additional hearings that will allow Mr. Becerra to proceed to get that psychosexual evaluation when in time and monies allow. Otherwise, the continued supervision of the child and the visits will be in place. All right, thank you. That'll conclude today's hearing.
Your Honor.
Yes, sir.
I did have a question. Is it just going to be a temporary until I can get that, or is it going to be set in permanent?
Yeah, that's a good question. Right now, that January 10th, 2024 temporary parenting plan is a temporary parenting plan. So the case is still, it's not resolved. So oftentimes what will happen, temporary parenting plans can last for months or years. And that's fine for some people. Having a final parenting plan is is helpful in that it resolves the case and that the issue of the controversy or, different viewpoints related to parenting plans. So at this point, I'm not going to push it one way or the other. I mean, we could set it for a trial date, note it up for a trial, and then have a final parenting plan. However, I don't know if there'd be much of a difference. It could be, but without that psychosexual evaluation, there's some unresolved issues that would remain at trial, and that may or may not turn out in a way one party or the other party may want. So kind of a long-winded answer.
I kind of wanted to just kind of get it over with because I keep missing stuff and I'm so if we could, I mean, push it along, and then I know that I can always revisit eventually. But yeah, I've just been dragging on, and I don't know
Yeah, I
how
mean,
it can.
yeah, if you're interested in moving the case along, you could note it up onto what's called the universal trial setting docket. That's just a
Okay.
docket where you say, hey, I want to have a trial on this parenting plan. And you'd give notice to Mr. Lawrence and also to Ms. Becerra, giving them notice on this is the date that we're going to go to court to choose a date in the future for a trial to get a final parenting plan.
Okay.
That's one option. Another option is to talk to the other party and come to some type of an agreement related to a final parenting plan. You'd have to run that by Mr. Lawrence. And if he's in agreement and all parties are in agreement, then it could be presented to the court for signature. If there's not agreement, then you could note it up for that universal trial setting docket.
Okay. That sounds good. I appreciate it.
Okay. All right. Mr. Lawrence, anything to add to that?
No, Your Honor.
Okay. All right. Very good. All right. So with that bit of direction, we'll let things stay where they're at, and then Mr. Becerra can make some decisions on where he wants to go.
Okay. Thank you, Your Honor.
All right. Thanks.
Ashley Becerra or Becerra and Joseph Becerra?
Here.
Here, Your Honor. It's Becerra.
Becerra, thank you. I see Mr. Lawrence is present. And this was on for a temporary change in the parenting plan, it looked like.
Yes, sir.
And we have a parenting plan that was entered in January, and you're asking to change that. That my understanding, is that correct? Okay. And let me see here just a second. And Mr. Becerra, did you receive all those documents?
So she sent me stuff on the 13th, and it said I had to the 15th to respond. So that's 2 days. That's not enough time to respond at all.
So this would have been, looks like it was filed on the 8th. Let me just check and see here. So that's not going to be sufficient time even if it was served that day.
Yeah.
I'm sorry, Your Honor. I thought I put the 25th down.
The 25th. I'm looking at your motion. It looks like it was filed on the 8th. It said for the 26th. And I didn't see an answer. So it sounds like this wasn't served for a few days at least. You said you got it on the 13th, sir?
Yes. I have proof of that too. Text message and email.
Okay, so that's going to be short service for today.
Yeah, I had to send it through email and I had to get it scanned in to be able to do that.
All right. And did Mr. Lawrence, did you receive a copy of that?
I did, Your Honor.
Okay. Mr. Becerra, were you planning on responding to that motion?
Yes, sir.
Okay. So today is short service for that. If you got it on the 13th, we'd probably be looking at least until next week. I could set it over a week, but you'll need to get how soon can you get your response filed?
I can't take any more days off this week, but I can try early next week. It's hard because
Okay. And you
I
could,
live in
you,
Central.
okay. So my thought then would be to, if you can do that by the first of the week, if I put this over 2 weeks to the 12th, that'll give you an opportunity to get yours filed. That needs to go to Mr. Lawrence as well.
Yep.
And then before we make any changes, I'd want to have some input from Mr. Lawrence, whether it's just verbal in response to those motions.
Okay.
But we need to get your response to that. It's not timely for today, and I'm not gonna make her start over from scratch, but let's go to the 12th, which is 2 weeks.
Okay.
Get your paperwork filed by the first part of the week, and then we'll be able to proceed.
Okay. Sounds good.
All right, so Ashley, if you can hear me out, we'll go over 2 weeks. You'll be getting an email from him with whatever his response is, and then Mr. Lawrence will weigh in when we come back on the 12th.
Thank
Okay.
you, Your Honor.
Thank you, Your Honor.
You're welcome.
Becerra and Becerra, if I'm pronouncing that correctly.
Ashley Becerra here.
And,
They're here also.
all right. All right, ma'am, is there anything you wish to say in addition to what you submitted?
Just to kind of respond to his response. He says in his response that I agreed to unsupervised visitation for him and my son. What had been discussed was that we would talk about it. I had not agreed to anything. As I was waiting for an appointment with legal aid at the time. And then when I talked to legal aid, we filed the parenting plan that you have in front of you. I get that he's upset that my son has had lice a couple of times. His older sister goes to school. She brought it home. The house has been treated multiple times. I've treated the kids' hair. It's gone again. I don't know why he is still making a big fuss about that when that was like last year when that had happened. And he has told me on more than one occasion that his sister falls asleep during visits because she works the night prior. And this was the time and date that they set for visitation. My son also tells me that his aunt sleeps when on visits. And my son has actually been asking to not go to visits lately because he's tired and he doesn't want to wake up at 6 a.m. on a Saturday to go see his father.
Right, sir, anything you wish to say?
Yeah, that's untrue. It'd be kind of stupid of me to say that my sister falls asleep. I don't know what she's getting at there. And no, it wasn't a year ago about head lice. He actually told me this last visit. I didn't ask about head lice. I asked him, "Hey, buddy, when did you get your hair cut?" "Oh, when I had bugs in my hair." And so he knows what head lice is, and he knows when he has to shave his head, and that's Ashley's treatment, is to shave his head. Which, I mean, I don't disagree with that. I mean, if it helps, it helps. He's a boy. He doesn't look horrible with a buzzed head, but my sister does work nights, and I don't know how he would see we're usually cooking or messing around at the table in her kitchen, so there's no her falling asleep. She's right there. I part of it is me and Ashley did agree, and she wouldn't do it in text form because she doesn't want me to have any proof of that. My sister was on the phone call when I was talking to Ashley about it, as I kept her in my pocket because I don't trust Ashley. So my sister did hear it. And after that visit, a couple other ones, and this has happened multiple times, Ashley will flirt with me sexually, and I deny those advances. And I think she got mad, and every time she gets mad about it, she'll pull up stuff, and because she has the power or something, I don't know, but it's frustrating. I have no interest in pursuing anybody, and all I want to do is see my son. And I've told Ashley that we can change times, and as I told her, she can be on the visits. If she would like to be the person that's on the visits, it's fine. I have nothing to hide. I just want to, be there for my son and provide him
with the love and, you know, just, you know, teach him that, you know, daddy's around, even though it's only 3 hours. Also, the original stuff with, I think is Judge Scudder, he gave me weekends and overnights, and then it went to 3 days or 3 hours on weekends. And in there, I also submitted about Mr. Lawrence. 2 of the items that I tried to submit, I got called and said I couldn't have them submitted. So only his email to me was submitted. And he said he didn't talk to anybody on Ashley's side, in which he did. He got that information. So I just don't trust that he's being fair.
Mr. Lawrence, anything you want to add?
Yes, Your Honor. The elephant in the room is that in my original investigation, which was included in my report, that I discovered that Ashley's older daughter, Mackenzie, had accused Mr. Becerra of sexually molesting her. I was also provided with the name of his former stepson to a relationship that occurred before Miss Becerra and he got together. And the boy's name was Matthew. And Matthew confirmed that Mr. Becerra had also sexually molested him. So I recommended to the court that Mr. Becerra undergo a psychosexual evaluation, which the court ordered. And Mr. Becerra has not completed that. And so that's why we have supervised visitation. It would be of extreme concern to me if his sister is sleeping during the visits. If she is not, well, that's fine. But somebody needs to be supervising these visits. And Mr. Becerra has indicated he can't afford the psychosexual evaluation, but that doesn't mitigate the potential risk to his son. So that's where we're at from my perspective, Your Honor.
Well, Mr. Becerra, what's the status of that evaluation?
It's over $1,000, and I pay Ashley child support, I pay my rent, I pay all my bills. So, and then on top of that, every week going to Longview, which is 100 miles round trip for myself. And I told Judge Evans that I don't know when I can afford that. Like I've had to rebuild my life because of Ashley, so I have bills out there that I'm trying to pay down. So it's taking a bit. And I could even prove with Ashley, her saying, you know, she's gotten back with me a year after these allegations happened. And I have other text messages, everything. I'm just trying not to drag her, you know, through the mud. I don't think it's necessary. And the Matthew thing's irrelevant.
Well, no, it's not. It's extremely relevant. That order for you to get that evaluation is an order, not a suggestion. And gee, you've got other bills you think are more important is not an excuse. So when is that going to get done?
As I told Judge Evans, and he agreed, he understood. He said, get it when you can. I understand. It's money doesn't grow on trees. It's I have to save.
In Your Honor, he gives me $400 a month for child support, which we agreed upon between him and I. And he does it like $100 or a $150 every week until he pays that full $400. I also waited to file anything about him not doing his psychosexual evaluation until I figured he could have his, taxes filed and his taxes come back. Because I figured with taxes coming back, he should have been able to fulfill that psychosexual evaluation with that money.
I owed almost $200.
Okay, well, here's where we're at. In the absence of that evaluation, we've got some extremely concerning allegations. Those allegations mean there has to be reliable supervision of any visits if there are going to be any visits. And if there's even a suggestion that the supervisor's not performing as they should, we're not going to be able to use that supervisor.
Well, then it makes us, I will find an attorney and come back to court for this because
Well, you're free to do that if you wish.
yeah, this is ridiculous. All my visit records were amazing where hers weren't. And I was on monitored visits. So they had no concerns. And she's never said she'd had any concerns that I did anything to my son either. So this is just ridiculous.
Your Honor, there's also been weekends where I've had to miss visits for Joe to see his son because I've been at the hospital with my daughter dealing with massive mental health issues from her abuse from Joe.
Yeah, we're going to have to come up with a different supervisor, and unless the parties can agree on who that's going to be, it's going to have to be a professional supervisor.
I won't agree with anybody that he puts in because the last time he tried to have supervisors, it was the kids' ex foster mom's mother and her husband or his sister, and I don't trust any of those people to truthfully watch the way they're supposed to be watching because they don't think that my daughter's telling the truth. And all I'm trying to do is make sure my son is safe when he's with his father.
All right, so I'm signing the order indicating the visits are to be professionally supervised, absent the parties' agreement on a supervisor.
With that signature, are you also agreeing to the 3 months for him to have the psychosexual evaluation done or forego visitation until it's completed? Because by the time that time frame's up, he will have had 9 months to complete that.
That is to be done by September 2.
So with that being signed today, Your Honor, does that mean that I don't have to take my son up there to see him on Saturday unless he has professional supervision prepared?
Unless there's professional supervision, the visits won't occur.
Thank you.
I have signed those orders.
Thank you, Your Honor.
Thank you, Your Honor.
Call next the Becerra matter. This is Ashley Becerra and Joseph Becerra. The cause is 19-300730008. I'll ask if the parties are present. I see Mr. Lawrence is present. He's the guardian ad litem. I'll ask if Ashley Becerra is on the line.
I am, yes, sir.
Okay, welcome to you, Ms. Becerra. And Joseph Becerra, are you on the line? All right, Mr. Becerra, if you're speaking, I can't hear you, so make sure that you're unmuted and again, just state your name so I know you're present. All right, not hearing a response or hearing from Mr. Becerra. Looks like there's no movement in the courtroom, so I don't see him here. We're on today for a pre-trial in preparation for the trial that's set for the week of October 14th. So
Yes, it's to finalize our divorce that's been in the works for 5 years, almost 5 years now.
right, yeah, and today's effort is to make sure that everybody's preparing for the trial, which is scheduled for the week of October 14th. And so I'll ask you, Ms. Becerra, do you have any questions in relation to your preparation for the trial related to witnesses, exhibits, and things of that nature?
No, we separated due to sexual assault from my husband to my daughter. And so we've been separated, like I said, for almost 5 years now. All of our assets are separated. We've gone through the parenting plan, custody things with our son. He didn't follow through on his stuff, so he's no longer allowed to see our son.
So, and then
So
in
it's pretty
preparation,
much just waiting for.
yeah, so in preparation for the trial, there's a couple things to keep in mind that generally parties will have a list of witnesses that they plan to call, and they'll have a general idea of what that witness is going to say. So they're kind of planning out their case. So you'd have a list of witnesses and make sure that they're in attendance, giving them notice. That's one thing to prepare for, and then be prepared if you have any documents or pictures or videos or things of that nature that you want to have the court look at. And you'd need to have a copy for the court, a copy for the other party, and a copy for yourself. So just make sure that you're prepared in that manner. Then also be aware that you can call witnesses, and you can also be called as a witness by the adverse party, and likewise you can call them as a witness. And be aware that also that after you've presented all of your evidence and you've testified and he's testified and witnesses for each have testified, then you'd be called upon to give a closing argument, meaning basically you would lay out your reason or rationale for why you should be the prevailing party. The other party would have that same opportunity. And then also if you want to prepare proposed orders, a lot of times people will prepare proposed orders in the fashion that they feel that the case is going to go in their favor. And so they'll prepare those and have those ready to go at the time of the trial. And that's something that's helpful for the court also. So if you want to do that, you're encouraged to do that. Last thing I wanted to ask, Mr. Lawrence previously filed a guardian ad litem report, a couple of them, it looks like. The last one was filed on December 13th of 2020.
Man, locked up.
Pardon me?
I think he's having difficulties with his
Zoom.
Zoom. Yeah.
Your Honor, I apologize. My screen locked up. I didn't catch what you asked.
Oh, I apologize. I was just mentioning that you had filed two guardian ad litem reports, one in 2021 and the other in December of 23. I was just teeing that up to see if your presence was required or if the parties would be relying upon your report only. So I was just kind of teeing that up. And obviously, if you wanted to be there, I'm not going to prohibit that, but I just wanted to touch base with Ms. Becerra what her thoughts were as far as your attendance. Ms. Becerra, do you want Mr. Lawrence to be there to testify live, or do you want the court just to simply rely upon his written reports?
I'm okay with him being there live to testify. His report has pretty much solidified our parenting plan, thanks to his investigations. I don't understand why this is such a big deal. It's literally, we've been separated for 5 years. We have nothing to do with each other other than our son. I'm literally just asking to finally not be this man's wife anymore. So I don't understand what orders need to be put in or anything like that, because I've already submitted the divorce decree and all of those papers prior.
Well, we're going to have a trial. We have a trial. The court needs to make findings of fact and conclusions of law, and that'll be based on the evidence that's presented. And when the trial's done, then you'll be done. You'll be divorced, and everything will be in writing. So the next court hearing is on October 8th at 11:30 a.m. That's to make sure everybody's ready to go. So we'll see everybody on October 8th at 11:30.
What happens if Joe doesn't show up again?
Generally, those tend to be fairly short trials. When we go to trial and one party is not present, then this court still needs to make findings of fact and conclusions of law. So one party presents their side of the case, and that's all the court hears. And generally, that goes well for the one party that's present.
Okay.
Okay.
Your Honor, I have a request. Normally, it takes about 3 hours of trial prep and an hour for appearance in court. Would the court consider granting me 4 hours of time to get set for the fact finding?
Sounds reasonable. I'll approve that.
Thank you.
Okay. All right. So we'll see everybody at the readiness hearing October 8th at 11:30 in the morning. Thank you.
Thank you.
Okay.